Hi guys, hope everyone is doing good and I hope everyone is on track in their studies for prelims exam. Today in News in 30 Minutes, let us look at some of the important issues on the 10th of January 2024. There are two very important issues that will give you a very good clarity about international affairs. So these two articles will help you write very good answers in your GS2's international relations. So that is the advantage of these two articles. Okay, so go through it thoroughly. The next is, I just wanted to tell you that this initiative will go up to April, and this initiative will give you a mix of both prelims and mains. Okay, so the point is, I will keep you tuned with respect to mains, especially the answer writing part, by giving you examples, case studies and etc., dimensions and so on. And I'll also keep giving you information about prelims that will help you in your prelims also. Okay, now the reason why I'm telling you this is a lot of students have this mains fear. Okay, I don't want you to keep being insecure regarding your mains preparation. Please forget everything about that and start your prelims preparation. If you need, you can revise for a couple of hours, you're optional. And anyways, the news in 30 minutes will do you a wonder in your answer writing by enriching your content, bringing dimensions and giving you different perspectives. Okay, so continue doing your news in 30 minutes up to April. That will keep you fine-tuned for your mains. It will also give you information regarding prelims, but start off your prelims preparation by starting off with the basic subjects so that you get a proper grip over those subjects. Okay, now for students who have started with your prelims preparation, for them I'm going to bring a surprise in the month of February that will help you people in your prelims preparation, but that has to wait. News in 30 minutes will continue till April, you don't have to worry. However, please switch over to your prelims preparation, but don't stop reading newspapers and don't stop seeing news in 30 minutes. With this, your mains preparation will keep strengthening. You have to have no doubt about it. Just focus solely on your prelims and clear prelims. If you clear prelims, I can promise you that you will be in a very good shape to clear mains exam. With that, let us start off with the important issues on the 10th of January 2024. The first issue is India refusing to lead active non-alignment? Okay, now this is a new concept that has been introduced. There is a word called active non-alignment. This is known as ANA, and this is a new keyword that is making a buzzword in a very recent times. It is said that this active non-alignment is a successor. It is a successor of non-alignment movement. It is a successor of non-alignment movement. Okay, so if you remember, non-alignment movement was a movement where India played a crucial role in forming this movement. It was formed in 1961, and this movement helped in fighting against colonization. So it played a very important role in decolonization and democratization of the global south. It played a very important role in decolonization and democratization of the global south. The next is, it has almost 120 members, which constitutes more than 60% of the overall members of United Nations. And it follows the 10 Bandung principles. These principles can be respecting each other's territorial sovereignty, not interfering in internal matters, promoting democratic principles, making sure that there is non-violence. So these are some of the 10 Bandung principles. Now 2019 to 2023, this particular non-alignment movement was chaired by Azerbaijan. It was chaired by Azerbaijan, and January 2024, there is going to be the 19th summit. There is going to be a 19th summit in the country called Uganda, and within Uganda in a place called Kampala. Okay, now this is an update regarding non-alignment movement. The reason I gave you this update is because it is important from prelims perspective. Such facts are very, very important. As I told you, from prelims, whatever you do, you have to make sure that you read less English and more factual dimensions. Read more and more factual dimensions whenever it comes to prelims. So from prelims point of view, I have covered what exactly is non-alignment. Okay, now from the mains point of view, let me just elaborate what this concept of active non-alignment movement is, or the active non-alignment as a concept is. Now, there was something called non-alignment movement, that is meaning that you don't have to be aligned with any of the two powers. This came in the period of Cold War. In Cold War, there was two blocks. You had USA and then you had USSR. Okay, so you had the capitalistic bloc as well as you had the communist bloc. So not aligning with either of the ideology is what is non-alignment. Okay, so this was what was non-alignment. Now the evolution of this non-alignment, which most of the global south followed, the evolution of this non-alignment is what they are calling as something called active non-alignment. A very interesting concept. India has implicitly already done this concept even before the birth of this term called active non-alignment, that is ANA. However, let me give you a background. One, it is a successor of NAM. It is a successor of NAM. The second is it is still in its infancy stage. It is still in its infancy stage. The third is it is popularized by an author called Orge Ain, H-E-I-N-E. It is popularized by an author called Orge Ain in the book that is Foreign Policies in the New World Order. Foreign Policies in the New World Order. In the New World Order. So in this book, the author has popularized this concept of active non-alignment. Now, what is the meaning of this active non-alignment? So, active non-alignment calls upon the government. It calls upon the government to not follow any of the global powers. Okay, to not follow any of the global powers. So that is one. You should not follow any of the global powers. The second is you should follow instead the defending of your national interest. The next is you should follow in defending your national interest. Okay, you should not give in to the pressures of the global power. You should not follow the pressures, or you should not follow any commandments given by the global power, or you should not give in to the pressures given by the global power. However, you should instead act. Your actions should always be in defending your national interest. Okay, now the two instances of active non-alignment that has happened is, one is if you take India during the Russia-Ukraine war. During the Russia-Ukraine war, India did not impose sanctions on Russia. It did not impose sanctions on Russia as per the demands of USA. As per the demands of USA, India did not impose sanctions on Russia. When cited, India told that it is being done on the basis of national interest. Look at this. Now, India is acting solely on the basis of national interest. It is not acting just because a West command or the West is commanding us to put sanctions on Russia. So this is the first instance. The second instance of active non-alignment is the Israel-Gaza war. In the Israel-Gaza war, there was a non-binding and symbolic resolution that was moved in the United Nations General Assembly. There was a non-binding and symbolic resolution moved in United Nations General Assembly. Okay, in order to immediately have a humanitarian ceasefire. They wanted to have an immediate humanitarian ceasefire, and in doing this, there was 153 countries that voted for yes, there has to be a ceasefire. 23 countries abstained and 10 countries voted against. So look at this. The amount of countries that are now opposing this Western narrative that Israel is only defending the attack of Gaza is being negated in the form of this resolution, which again points out that the active non-alignment is in play. So these two instances show that we are moving from non-aligned movement towards active non-aligned movement. Okay, now the next is, what is this active non-aligned movement that is becoming very famous? Because this is establishing a new global south order. This is establishing a new global south order. That is why it is becoming important. The reason is, see, global south is all the developing countries, all the third world countries, all those colonial nations which suffered from the imperialism of the West. So anti-non-aligned movement, I'm sorry, not anti-non-aligned movement, I'm really sorry, it is active non-aligned movement. This active non-aligned movement is nothing but a anti-Western axis. Basically, it's an anti-Western axis. So we are not going to play by the rules of the Western narrative. We are going to play by the rules of national interest. That is what the global south nations are telling. So it signifies the coming of the new global south order. The example why we are telling that it is not coming up with the new global south order is, I gave you the example of India. I gave you also the example of UNGA regarding the Israel-Gaza war. Few more examples that I will give is, see, 21 Latin American and Caribbean nations. 21 Latin American Caribbean nations have now sided to the China's new Silk Road. Okay, it is sided to the China's new Silk Road. It is now signing up for China's new Silk Road. Okay, this again is against the narrative of USA and its democratic way of expanding power. Okay, then one more example I will tell you is, there are 4 Latin American countries. There were 4 Latin American countries, that is Argentina, Brazil, Chile and Colombia. So USA approached these nations and told that it will modernize its old weapons inventory. It told that it will modernize its old weapon inventory, and these nations rejected it. So all these are signs that active non-alignment is in play. Okay, so this is what is the new global south order. Now I would like to correlate this active non-alignment with the concept of something called multi-alignment. Okay, so this concept of multi-alignment is something that was introduced by our Minister of External Affairs, Mr. S. Jaishankar, in the book written in 2020 that was called The India Way. It is called The India Way, and in this India Way, S. Jaishankar has introduced something called multi-alignment. Very beautifully, this multi-alignment is defined as, India seeks strategic convergence. India seeks strategic convergence rather than seeking tactical convenience. Tactical convenience is trying to use situations to our advantage, which India does not do. India will always like to converge with all the nations strategically. That is, it likes to help one another, it likes to share best practices, it likes to share each other's burden, and that is what is strategic convergence. To move beyond the relationship of trade and to converge strategically so that we can grow together is something called multi-alignment. So this article very beautifully has explained the concept of active non-alignment, which is the successor of non-alignment movement, and also this can correlate with the concept introduced by our Minister of External Affairs, that is the S. Jaishankar, who was introduced in the book The India Way, the concept of multi-alignment. Okay, so India is currently showing the prowess through the means of multi-alignment, and implicitly it is acting on behalf of national interest, which also shows that India is also towards active non-alignment as well. So I hope you got a very good understanding of what this concept of active non-alignment is. Okay, so this is about this article, a good article that you can use in your answers. A very excellent keywords of multi-alignment and active non-alignment as well as non-alignment. These concepts can be used in your answers regarding international affairs on different concepts within that. Okay, so this is about this issue. The next issue also is regarding international relations that can help you in enriching your answers in GS2, the third part of international relations. Okay, here the the argument basically is why international law matters, because there are two arguments. Some argument is it matters, some argument is it doesn't matter. Okay, some will argue that it doesn't matter, some will argue that it will matter. So that is a very excellent point that you can use in your answers. Okay, so let us, before getting into this, the entire argument starts because of something called Article 2 of United Nations Charter. Okay, the Article 2 of United Nations Charter. So let me just give you a brief of what is this Article 2 of United Nations Charter. Again, you can use this in your answers. You don't have to wait for them to ask you exclusively. You can use this Article 2 implicitly in your answers to substantiate different aspects. However, Article 2 of 1, okay, Article 2 of 1 talks about something called principle of sovereign equality. It talks about principle of sovereign equality. Article 2 of 2 talks about all members are getting their rights and benefits equally. All members of the United Nations should get their rights and benefits equally. Article 2 of 3 tells that they should all members should settle international disputes peacefully. Okay, the next is Article 2 of 4 that talks about they must refrain, all members should refrain from threat or use of force. Okay, and should never go against territorial integrity, or political independence of any state. Look at this. These articles shape the international laws within the international institutions that come under United Nations. So this Article 2 of United Nations Charter is very, very important in shaping the international laws that we use in our global communication or global interactions. So to repeat, Article 2 of 1 talks about the principle of sovereign equality. Article 2 talks about all members enjoying the equal rights and benefits. Article 2 of 3 says that all members should resolve their international disputes peacefully. And Article 2 of 4 should say that it refrains, or all members should refrain from threat or use of force, also should respect the territorial integrity and the political independence of other states. Now, the reason of contention is there is someone called Thomas Frank. Thomas Frank is an international thinker as well as an international affairs writer who has told that this Article 2 of 4 is dead. He has told that Article 2 of 4 is dead. And a lot of international thinkers have told that this entire article of Article 2 of United Nations Charter is redundant and it is ineffective. Okay, that is the entire argument that happens within this article. That is this Article 2 of United Nations Charter relevant? The reason is because, see, one, they tell that principle of sovereign equality, that is all sovereign nations are equal. Are we really equal? If you look at the United Nations Security Council, we don't see that. If you see United Nations Security Council and United Nations General Assembly, we don't see any type of equality there. Now, all members enjoy rights and benefits equally. Again, this is not seen within the United Nations. The next is all members should settle international disputes peacefully. We are not seeing the peaceful settlement of disputes. All members should refrain from threat or use of force. If you look at South China Sea, if you look at Russia-Ukraine war, if you look at Gaza-Israel crisis, all this shows that there is threat and use of force and the international disputes are not settled peacefully. So all this points to the Article 2 of United Nations Charter being ineffective. Okay. However, we cannot take it completely negative. So now comes an argument of, is the international law really relevant? So first let me argue it is not relevant. The reason why I will tell you it is not relevant is the international law was created with a presumption. The international law was created with the presumption that the United Nations Security Council will work. Okay, it will work in a cooperative manner just like it did before or during World War II. Now, before or during World War II, this United Nations Security Council members had to work cooperatively. Before, don't say before, or just post World War II or during World War II, they worked cooperatively. Correct. However, now these 5 nations which are part of the permanent 5 need not have to work cooperatively, because post World War II a lot of geopolitics or global politics has changed. So now they are not working collaboratively. So that is making the international law less relevant. Okay, so the entire international law that is based on UNSC working cooperatively itself is flawed, because that convenience of partnership happened during World War II or post World War II, which now is irrelevant because of the changing geopolitics. That is the first reason. The second reason is what they say is the international law lacks global police. When the international law lacks global police, obviously then it will also lack global enforcement, because there is no one to punish them. So because there is lacking of global police, there is lack of enforcement of international law. The third argument is international law shows poor compliance. The best example is China being ordered by the Permanent Court of Arbitration regarding UN clause to respect the laws of UN clause in South China Sea. However, China has given utter disregard to this judgment, and China has gone ahead with this 9-dash line. Correct. So this shows that there is poor compliance of international law. Hence, they say that international law is anyway inconsequential. Inconsequential is because it will not result in any type of consequence. So these are some of the arguments made by few authors or thinkers who say that international law are irrelevant. So let me repeat. One, the entire presumption that the permanent 5 of the United Nations Security Council work collaboratively is because in World War II or post the World War II, it required them to work collaboratively. But now the geopolitics has changed, which need not make them work collaboratively, which we are seeing. The next is it lacks global police, hence there is no enforcement. The third is it lacks poor compliance, which is evident because of the utter disregard that is done by these global powers themselves. Okay, so all this points to the less relevance of international law in global geopolitics. Now the next argument I will do is international laws are relevant. The next argument is international laws are relevant. The first argument is national courts. Okay, the national courts will use this international law to interpret domestic laws. Okay, one, they will use this international laws to interpret domestic laws, and the second is it will also use to enlarge and enrich its domestic content. It will enlarge and enrich domestic content. For example, see, I'll give you an example of how internet became a fundamental right. Okay, so internet became a fundamental right first in the global arena, and from this our national courts took up this idea and then used it as a part of the fundamental rights of India. That is, internet is now part, or accessibility to internet is part of the fundamental right in India. Okay, so why we got this idea is because of the global laws or the international laws that included this as a part of human rights. Okay, the access to internet is now part of the human rights internationally. So from this we have taken the idea into our laws. So this is how international law becomes relevant. The second is whenever a country engages in international law, then global norms within the country are debated, which we are doing now, are debated, are interpreted, and they are internalized. They are internalized into the domestic legal system. Okay, domestic legal system. It can be anything. See, I'll again give you an example. Biodiversity conservation. Okay, if you take biodiversity conservation, the international law came up first. For example, you can take the UNESCO's Man and Biosphere program, or if you can take the Stockholm Convention. See, from Stockholm Convention, we came up with something called, Wildlife Protection Act 1972. From UNESCO's MAP program, we came up with something called biodiversity conservation or biodiversity biospheres, the concept of biospheres within India. Also, if you take up the Rio Summit, from Rio Summit, we have now got something about conservation of biological diversity. From this comes our law of Biodiversity Act 2002. See how countries engaging in international law will lead to debating, interpreting and internalizing these international law. That will further lead to domestic legal system that gets enriched. That is why international law is very, very important. Okay. The third point why international law is very important is it makes the ability to distinguish. It makes the ability to distinguish. One is on one side there is sheer power versus legitimate power. Sheer power versus legitimate power. Okay. Now, very good example that the author gives here is the author says in December 2023, South Africa approached the International Court of Justice and complained against Israel. Why did it complain against Israel? It complained against Israel that it is violating a convention called, it is a convention on prevention. It's a convention on prevention and punishment. Convention on prevention and punishment of crime of genocide. It was a convention on prevention and punishment of crime on genocide. So South Africa has gone and complained to International Court of Justice against Israel that they are committing genocide in Gaza and they are violating Convention on Prevention and Punishment of Crime of Genocide. Now they complained in ICJ, though not much actions were taken, it forced the Israel Defense Force to come up and explain their military offensive. See, implicitly it has acted in the Israel to come and take up the accountability of what they are doing. If even this was not done, then how will you differentiate sheer power from legitimate power? Okay. Now Israel can show sheer power and destroy the entire Gaza. If someone wouldn't have questioned that sheer power, then how will you differentiate sheer power from legitimate power? Legitimate power is the power that protects the people. Sheer power is the power that protects the land. So what is the differentiation between protecting the people and protecting the land? So this is the ability that distinguishes the international, the ability to distinguish this comes from international laws. So I hope you understood the three important points. Along with this, one more international author says that, one more international author says that the international law, okay, if you take the international law, though there is no universal compliance, international law will always create universal aspirations for compliance. Okay, though there will not be universal compliance, the international law will always have universal aspirations for compliance. Okay, further, the conclusion of this argument is international laws are very much required. It is required in order to constrain. One, expansionist policies. Okay, it is required to constrain imperialistic policies and illiberal policies. So if we have to stop expansionist, imperialist and illiberal policies of the global powers or any international sovereign nations, then international law becomes very, very important. It is this law that will provide the framework for all the government legislations and courts to work in synchronous. So international laws become very, very important. So with that, we conclude this particular issue and let us go on to the next issue of the day. The next issue again is Justice for Bilkis Bano, questions on remission. Okay, so basically the question here is, yesterday we discussed about the recent Supreme Court order of those convicts who were awarded the remission to go back and surrender, and the Supreme Court has squashed the remission for these convicts. It has squashed the remission of these convicts. The reason is because of the state government of Gujarat that has usurped power and it has misused the Supreme Court judgment. Okay, it has misused the Supreme Court judgment. Now this we also discussed in the yesterday's news in 30 minutes, the pardoning powers. We discussed the pardoning powers of the president, pardoning powers of the president as well as the governor. We discussed in detail about this. Pardoning president of the pardoning powers of the president under Article 72 and pardoning powers of the governor under Article 161. We discussed about this. Okay, how they have the power to pardon, how they have the power to respite, they have the power to reprieve, they have the power to remit. Okay, as well as they have the power to suspend. So we also discussed what are these terms called: pardon, respite, reprieve, remit, and suspend. But in this particular article, there is more talking about here this part. Okay, now what is this remission? Okay, what is this remission policy with regards to state government? Okay, so now let us look at it in detail what this article talks about remission or remission policy. The remission policies that we see in the state government, that is what this particular article is talking about. So let us now dwell a little bit deeper. So if you take the remission policy, now the remission policy is done at the state government. As I told you, because the remission can be given at the state level by the governor on the advice of the Council of Ministers. Okay, it is not the discretionary power of the governor under Article 161. It is the aid and advice of the Council of Ministers that the governor has to abide. So on the basis of that, all the states have created something called remission policy. That is one. The second is prison is also a state subject. Prison is also a state subject, and many of the remission policy, many of the states have brought their remission policy under prison rules. They have brought their remission policy under prison rules. As one prison is a state subject, many states have prison rules or prison acts. They have created their own prison rules or prison acts, and within this prison rules or prison acts, they have also included the remission policies. Okay. Now the third is, why do we need this remission policy? Because we need this remission policy because in India, if you take the central government or if you take the state government, in India, our criminal justice system is reformative system and not, it is reformative system and not retributive system. See, reformative system is you will always give a scope for a person to correct oneself. Correct, not corrupt, sorry. Okay, you will always give a scope for the person to correct oneself and to also try to be apologetic to what has been committed. So you are giving scope for that person to reform. Okay, retributive means you are only trying to get revenge. Okay, so basically our criminal justice system is reformative. So as a process of reformation, our criminal justice system will always give scope for remission. And as the name suggests, remission is basically reduction. Remission is basically reduction in duration of punishment. Reduction in duration of punishment without altering the character of punishment. Reduction in the duration of punishment without altering the character of punishment. Okay. The next point is, so in several remission policies of the states, if you take the several remission policies of the states, these remission policies says that a person is eligible for, okay, if there is a convict, this convict is already getting a term of life imprisonment. Let us say this person is already got a term called life imprisonment. Now this convict who is a life convict, they are called life convicts. These convicts who have already got life imprisonment are called life convicts. If they have to become eligible, for applying for remission, then before applying they have to complete their 14-year terms. Only when they complete their 14-year terms they are eligible for remission. This is regarding the remission policies of the state. Okay, they have to complete 14 years and post 14 years they are now eligible for application for remission. Okay, the next is, once the person applies for remission. Now, once a person applies for remission, there is no guarantee that person will get remission. The person need not get remission. Okay. However, the sixth point is very important. Each application should be individually considered. This is where the Gujarat government did not do it. Each application should be individually considered. Okay. And it should also be tested for the following guidelines. I'll repeat again. Each application should be individually considered, and a committee that is set up to consider this remission must look into the following factors. Who laid out these following factors? The following factors was laid out by the Supreme Court of India in Laxman, Naskar versus State of West Bengal. Okay, 2000. In this Laxman, Naskar versus State of West Bengal, the Supreme Court has laid out certain factors. This committee that is set up to consider the individual remission should look into these factors, and if all the factors satisfy, then the individual must be given the remission. What are the factors? The factors includes: 1. Examine whether the act of offense of the individual does not affect the society at large. Okay, the act of an offense of an individual does not affect the society at large. That is one factor. The second factor is there any chance of reoccurrence of the crime? That is the second factor. The third factor is what is the potentiality of the convict in committing the crime again? That is the third factor. The fourth factor is there any purpose to keep this person in prison for more time? That is the fourth factor. And the last factor is the socio-economic conditions of the convict's family. Okay, so these are the 5 factors that was laid out in the Laxman Naskar versus the State of West Bengal. The first is, if the act of offense is affecting the society at large, is there any chance of reoccurrence of such crime? Is there high potentiality of that convict to commit a crime again? Is there any purpose of keeping this convict in jail for more time? The last is the socio-economic conditions of that family. Okay, now this is what now the Supreme Court had been ordered in Laxman Naskar versus State of West Bengal. Now what did Gujarat government do? Gujarat government gave en-masse remission. That is, it gave remission for everyone under the same condition with the same application. This is wrong. As the Supreme Court has told, the remissions should be considered individually. Every individual, if there are 11 convicts in that case, all 11 convicts should have been considered individually, and they should have been rated on the basis of different factors. Okay, and on the basis of that, they should have been given the remission. But this did not happen. They were given en masse remission, and everyone were given the same note by the committee on why the remission has to be given to them. So everyone were given the same notes. There was no change in the literature or the language that showed that it was breach of law. Okay, that is the 6th point. The seventh and the last point in the remission policy is, according to Eupuru Sudhakar, Sudhakar versus the State of Andhra Pradesh. Eupuru Sudhakar in the State of Andhra Pradesh, 2006. According to this judgment, judicial review of the order of remission. Judicial review of the order of remission can be done only if there is non-application of mind, or if relevant materials are not considered, or if there is any malified intentions. Okay, so if these are the 3 cases, then the courts can intervene in this order of remission. That is what has happened even now. Why did the Supreme Court intervene? Is because it felt that there was some malified intention and there was arbitrariness. There was arbitrariness in whatever has happened. So this is an entire conceptual understanding of how the remission policy works at the state level. So let me just give you a summary of this. Remission policies at state level will have the state governments creating these remission policies. As the prison is a state subject, remission policies are also put under the prison rules. The remission in India is important because India's criminal justice system follows a reformative part and not retributive. Remission policies, especially followed by the state governments, have a rule that if a life convict has to apply for remission, that person has to fulfill the first 14 years and only then is eligible for application of remission. The next is, once that person applies for remission, then there is no guarantee that person will always get remission. They may not get remission also. Each application should be considered individually according to Laxman Naskar versus the state of West Bengal case of Supreme Court in 2000. And here the Supreme Court has laid out 5 important factors which the committee has to assess before individually considering remission for that individual. And that 5 factors are the act of offense. Is it affecting the society at large? Is there any probability of reoccurrence of such a crime? Is there high potentiality of the convict to commit a crime again? Is it fruitful for purpose of keeping that criminal or keeping that convict in the jail for more time? And then the last is the socio-economic conditions of that particular convict. On the basis of these 5 factors, they have to consider whether the remission has to be given by or not by the committee constituted by the state government. Okay, and the last is the judiciary can intervene in the order of remission if there is non-application of mind, relevant materials are not considered, malified intention or arbitrariness, according to Eupuru Sudhakar versus the state of Andhra Pradesh in 2006. So this is the conceptual understanding of what is the remission policies that occur in the state government. So I hope this was clear. Okay, the last issue is again a case study. The case study that makes us, unfortunately, that makes us feel ashamed. This is the case study of the practice of untouchability. Okay, it is a practice of untouchability. So, in the region of Gollarahatti, there was a temple, and this temple is known as Kambada Ranganatha Swami, okay, and Timappa temple. Kambada Ranganatha Swami and Timappa temple. Okay, and the local residents of this temple had locked the temple, citing that there were Dalits who were trying to enter the temple. This is a complete breach of our constitutional values and the concept of Article 17, which is banned according to the constitution, that is untouchability. Okay, as you can see the headlines, Gollarahatti temple issue, Dalits enter the premises in the presence of officers. Look at it, they have to come in the presence of officers. Why should they come in the presence of officers? Why can't they enjoy their rights equally as others that is enshrined within our constitution? Okay, now one more information that you should understand is when the officers tried to enter the temple, the people of that region refused the keys. They refused the keys, and because they refused the keys, the officers had to break the lock. They had to break the lock and then enter the temple. Okay, now why am I giving you this case study is because I want you to think. Why is it that people are acting this way? Why isn't it that our constitution was enacted in 1950 and it has been more than 70 years that our values are enshrined, but these values are not internalized. Okay, so think why our constitutional values are not internalized. The second, think why people are not aware of the legal difficulties as well as the penalties that are there for such a crime, and also try to think from the people angle, what is it that we have to do to change the attitude and behavior of these people, because laws can only restrict external behavior, but how do we change the internal behavior of those people so that they have and they look at others, especially Dalits, as they are part of fraternity and as they are part of brothers, as enshrined in fundamental duties. Also, one more thing I want you to think is, if you are part of the taluk administration, what is it that you will take as a short-term measure and what is it that you will take as a long-term measure to overcome this problem? Okay, these are all something that you have to think, because you people are aspiring to be officers. You will be put across such instances where you need to have some type of an idea to work out to make sure that you address the problem of the people, you overcome the prejudice that is there within the people, and you also make sure that equality prevails without any type of violence. Okay, I'll tell you, see, officers went there when the people refused the keys. The officers broke the key and then took the Dalits and entered the temple. That is good. Now, do you think this solution is short term? It is definitely short term. Now, you have to convince the people. You have to change the minds of the people. Otherwise, officers cannot come with Dalits every time to enter the temple. There can be violence that can break down in the long term when officers do not accompany the Dalits. Don't you think that's a problem? So, whatever the officers have done is short term in nature. What can be the long term solution is what I want you to think, as the entire initiative of this is to make you a thinking individual. Okay, develop this ability and it is going to be helpful for your prelims as well as mains. I hope the issues were helpful and I hope you're enjoying the current affairs. If you enjoy this, please make sure that you like, please make sure that you share, and please make sure that you subscribe. Make sure that all your friends subscribe this channel so that they can also make use of this program. Thank you so much guys for all the love and support. I'm going to see you tomorrow. Bye.